5 states in America will take the family home the moment a senior enters long-term nursing care, and the first claim filed is the government's, not the family's. The rule is called the Medicaid Estate Recovery Program, and federal law not only permits it, federal law requires every single state to operate one. But the 5 states on this list have built the most aggressive versions of the program in the country, and in one of them, the claim gets filed while you are still alive, sitting at home with no court hearing and no notice to your children. This is not about poor planning. This is not about people who waited too long. In every single one of the families who lose the house was legally theirs until the moment long-term care began. Therefore, the question is not whether your parents own their home. The question is whether the state they live in allows the government to stand in front of the family when the house changes hands. The 5 states are Massachusetts, Ohio, Iowa, New York, and Florida. Each one uses a different rule. Each one targets a different part of the estate. And in the 5th state, the trap is designed specifically for seniors who retired there from somewhere else, which means hundreds of thousands of snowbird retirees are exposed and have no idea. Therefore, to understand how the family home gets taken, you first have to understand what the Medicaid Estate Recovery Program actually is, because the rule itself is written in a way that gives the states enormous room to maneuver. The Medicaid Estate Recovery Program was created in 1993 under the Omnibus Budget Reconciliation Act. Before that year, estate recovery was optional. After that year, every state in the union was required to recover long-term care costs from the estate of any Medicaid recipient who was 55 years old or older at the time of service. That is the federal floor. No state can opt out. But the statute left the definition of the word estate up to the states themselves. Some states defined estate narrowly, meaning only assets that pass through probate. Other states defined estate broadly, meaning every asset the senior ever had an ownership interest in, including jointly held property, life estates, transfer on death deeds, and even assets moved into certain kinds of trusts. That one definitional choice is the single most important variable in whether the family keeps the house or loses it. The second variable is the look-back window. Federal law allows states to reach back 5 years into the senior's financial history and reverse most asset transfers made during that period. But a handful of states have stretched that window through lien mechanisms that start the clock even earlier, and in some cases, attach a claim to the home while the senior is still alive. Therefore, the word recovery is misleading. In the aggressive states, recovery happens in real time, not after death. The third variable is who gets targeted. Federal law requires states to pursue the senior's own estate, but some states extend that reach into the surviving spouse's estate after the spouse later passes, which means a married couple who believed the healthy spouse was protected sometimes discovers that the healthy spouse's estate is on the hook for care the sick spouse received years earlier. These 3 variables, the estate definition, the look-back mechanism, and the spousal reach, are what separate the 5 aggressive states from the rest of the country. So here's the first one. Massachusetts operates the Mass Health Program, and Mass Health is historically regarded as one of the most aggressive Medicaid estate recovery operations in the country. The reason is a rule written into Massachusetts General Laws Chapter 118E, which allows Mass Health to place a lien on the senior's primary residence while the senior is still alive, not after death, the moment the senior enters a nursing facility and is deemed permanently institutionalized. That is the lifetime lien. The lifetime lien has 2 devastating effects. First, it publicly encumbers the home, which means the family cannot sell, cannot refinance, and cannot transfer the property without satisfying the lien. Second, the amount of the lien grows every single month the senior remains in care, because nursing home care in Massachusetts commonly runs between $14,000 and $18,000 per month, and every month of that care gets added to the state's claim. Therefore, the mechanical reality is this. A senior enters a facility in January. By December, the lien on the home has grown by roughly $170,000. After 2 years of care, the lien often exceeds $350,000, which, in many middle-class Massachusetts towns, is more than the equity in the house. The family home in that scenario is effectively owned by the state, even though the deed still has the family name on it. But the family almost never sees this coming. The lien gets filed with the Registry of Deeds at the county level, not at the family address. No letter goes to the adult children. No notice appears on the senior's mail. The first time most families learn about the lien is months later, when they try to list the house, or when they go to refinance, or when the senior passes away and the estate attorney opens a title search and finds the claim already attached. The lifetime lien also complicates the one tool that most families assume will protect them, which is transferring the home into the adult children's names before the 5-year look-back begins. Massachusetts does not consider that transfer a clean break. The look-back still applies. Therefore, a transfer made 4 years before nursing home entry still triggers a penalty period during which Medicaid will not pay for care, and during which the senior's private funds must cover the bill at the same $14,000 to $18,000 monthly rate. The mitigation commonly used in Massachusetts is an irrevocable asset protection trust, drafted and funded at least 5 years before the senior is likely to need long-term care. Properly structured, the home goes into the trust. The senior retains the right to live there, and after 5 years, the home is no longer counted as an available asset for Medicaid purposes and is no longer subject to the lifetime lien. The catch is that the trust must be drafted by an elder law attorney familiar with Massachusetts rules. It must be funded with the home deed retitled into the trust, and it must sit untouched for the full 5-year window. Any funding done inside 5 years of application gets reversed. But there is a deeper wrinkle that surprises even careful families. The lifetime lien attaches at the moment the senior is deemed permanently institutionalized, which is a clinical and administrative determination, not a voluntary one. A senior who entered the facility intending a short rehabilitation stay and who later has that stay reclassified as permanent gets the lien applied retroactively to the reclassification date. Therefore, the timing of that classification and whether a family contests it is itself a legal fight worth having with an elder law attorney before it happens, not after. Massachusetts is the lifetime lien state. The claim lands before the senior dies. That was a loop opened at the start of this video. Therefore, the family never gets a chance to react unless they plan years in advance. Ohio uses a different mechanism, and it is arguably worse for married couples than what Massachusetts does, because Ohio reaches past the original recipient and into the surviving spouse's estate after the healthy spouse later passes away. This is called expanded estate recovery, and Ohio is one of the most aggressive practitioners of it in the country. The federal rule is straightforward. When a Medicaid recipient dies, the state can recover from that recipient's probate estate. If the recipient is survived by a spouse, recovery is deferred until the spouse also passes. Most states, at that second death, recover only from what remains of the original recipient's share. But Ohio recovers from the entire combined estate of the surviving spouse, including assets the surviving spouse brought to the marriage, earned during the marriage, or inherited from outside sources. Therefore, the practical consequence is this. A senior husband enters a nursing facility in Ohio, qualifies for Medicaid, and receives care for 3 years at a commonly reported cost of $9,000 to $12,000 per month before he passes away. The state has a claim in the range of $324,000 at a minimum. His widow continues living in the family home. She lives another 9 years. When she passes, the state of Ohio presents the claim against her estate, which includes the home, the retirement account she inherited from her late sister, and the certificate of deposit she opened with her own paycheck 40 years earlier. The claim is satisfied first, and the children inherit whatever is left. But here is the wrinkle that most Ohio families miss. The widow cannot give the home away during her lifetime to avoid the claim, because Ohio's look-back rules apply to her as well from the date of her own application, if she ever applies for Medicaid. And even if she never applies, transferring the home to the children within a certain window before her death, combined with her continued occupancy, can, in some cases, trigger an inclusion rule that pulls the home back into her estate for recovery purposes. Therefore, the simple approach of deeding the home to the kids and moving on does not work cleanly in Ohio. The mitigation commonly used in Ohio involves a combination of transfer-on-death designations for non-home assets, a life estate deed, or ladybird equivalent for the residents, and in higher value estates, an irrevocable asset protection trust funded before either spouse enters long-term care. The life estate deed is a specific legal instrument that allows the senior to retain occupancy rights for life, while transferring the remainder interest to the children, and in most counties, it bypasses probate. If the home is not in probate, Ohio generally cannot recover against it under the program's narrower definitions. But Ohio has debated expanding the definition in recent legislative sessions. That is a moving target, and the state's position in any given year depends on the current administration and budget pressures. Therefore, the decision of whether to use a life estate deed, a trust, or another mechanism in Ohio is not a one-size-fits-all choice. An elder law attorney licensed in Ohio needs to review the couple's full asset picture, because the wrong tool can create a capital gains problem for the children that costs them tens of thousands of dollars, even when the Medicaid problem is avoided. The rule is complicated, and the stakes are high. But the single biggest unforced error in Ohio is the widow who sits on the home for years, believing that because her husband's Medicaid claim was temporarily deferred, it was permanently waived. It was not. It was waiting. Iowa uses a mechanism that catches even families who have done extensive estate planning, because Iowa reaches through the survivor death and pulls jointly held property back into estate recovery at the moment the second owner passes away. That is the joint property survivor rule, and Iowa has historically interpreted it broadly. Most families who own property jointly assume the property is protected, because joint tenancy with right of survivorship means the property passes outside of probate to the surviving owner. That is true for most legal purposes, but Iowa's Medicaid estate definition, codified under Iowa Code Section 249A.53, includes any asset the Medicaid recipient had a legal or equitable interest in at the time of death, including assets passing by joint tenancy. Therefore, when the recipient dies, Iowa treats the recipient's prior interest in the jointly held property as recoverable, and that recovery gets activated when the surviving joint owner later passes. The practical consequence plays out most often with adult children who added their name to the parent's deed years earlier, believing they were simplifying the inheritance. In Iowa, that joint tenancy does not always insulate the property. When the parent enters a nursing facility, qualifies for Medicaid, and later passes, the state's claim attaches to the parent's prior half interest in the home. The adult child inherits the full property on paper, but when the child later sells the home, refinances it, or passes it to their own heirs, the state's claim surfaces in the title search and must be satisfied. The dollar consequence depends on how long the parent received care. Iowa nursing facility costs commonly run between $8,000 and $10,000 per month. A 3-year stay produces a claim in the range of $288,000 to $360,000, and the state files that claim against the parent's notional share of the joint property, which in most cases is 50%. Therefore, the simple joint tenancy strategy that works in many other states can fail in Iowa. The adult child ends up selling the home and handing roughly half of the sale proceeds to the state, even though the child's name was on the deed for 20 years before the parent ever needed care. The mitigation commonly used in Iowa is either a transfer on death deed, which Iowa has recognized under its transfer on death statute since the mid-2010s, or an irrevocable trust funded outside the look-back window. The transfer on death deed allows the parent to retain full ownership during life, transfer the home automatically at death, and avoid probate. And because the home transfers at the moment of death, rather than being jointly held during life, the asset is generally not subject to the joint property recovery rule. But transfer on death deeds only work if executed correctly, recorded in the proper county, and not revoked by any subsequent deed or will provision. A single clerical error in the filing has been enough in reported cases to invalidate the deed and expose the home. Therefore, the instrument matters, the recording matters, and the interaction with any existing will or trust matters. An elder law attorney familiar with Iowa's transfer on death statute should review the deed before it is filed, and the family should request a certified copy of the recorded deed after filing to confirm it was accepted by the county recorder. But the deepest trap in Iowa is not the joint property rule itself. It is the families who did everything correctly 20 years ago and assumed the rule had not changed since then. It has changed. Iowa has updated its estate recovery framework more than once, and families operating on an older understanding of the rules are exposed in ways they do not know. New York operates Medicaid through the State Department of Health, and New York is the state most commonly associated with Medicaid asset protection trusts. The irony is that New York is also the state where those trusts most commonly fail when they are set up incorrectly, because the New York rules around the 5-year look-back interact with trust funding in a way that surprises even families who paid thousands of dollars for the planning. The core New York rule is that assets transferred into an irrevocable Medicaid asset protection trust are treated as unavailable for Medicaid eligibility purposes 5 years after the transfer date, not 5 years after the trust creation date. This distinction matters because many families sign the trust document today, but fail to retitle the home into the trust until months or years later. The look-back clock does not begin on the day the trust was signed. The look-back clock begins on the day the deed transferring the home into the trust is recorded. Therefore, a family that created the trust in 2020 but did not retitle the home until 2022, has a 5-year window that does not close until 2027. If the senior enters a nursing facility before that window closes, the home is still inside the look-back, and the state may treat the transfer as an attempted disqualification, which triggers a penalty period during which Medicaid will not pay for care. Private pay at New York nursing facility rates, which commonly fall between $16,000 and $22,000 per month, then drains the senior's other assets at a pace that can exhaust a $700,000 nest egg in under 3 years. But the deeper New York trap is the requirement that the trust must be truly irrevocable and that the senior must not retain any incident of ownership that would cause the asset to count as available. Some attorneys draft trusts that include powers of appointment, retained income interests, or reserved rights that, while legally valid for other purposes, accidentally trip the availability rule for Medicaid. The Department of Health's reviewers look at the trust document line by line, and a single provision that gives the senior ongoing control can result in the entire trust being disregarded and the home being treated as if it had never been transferred. Therefore, the mitigation commonly used in New York is an irrevocable trust drafted by an attorney who regularly handles Medicaid planning for Department of Health applications, combined with a strict waiting period of 5 full years between deed transfer and Medicaid application, combined with no modifications, withdrawals, or amendments to the trust during that window. Any one of those 3 variables being wrong can collapse the entire plan. New York also offers a narrower workaround called the caretaker child exception, which, in certain circumstances, allows the home to be transferred to an adult child who lived with the parent and provided care for at least 2 years before the parent's nursing facility admission, without triggering a look-back penalty. The documentation required to prove caretaker child status is substantial. The adult child needs proof of residence, proof of care provided, and commonly, a physician's affidavit stating that the care kept the parent out of a facility during that 2-year period. Families who qualify for this exception can save the home outright, but families who try to qualify without proper documentation and lose the claim end up worse off than if they had never attempted the transfer. But the single biggest New York mistake is assuming that the trust alone is sufficient without an elder law attorney periodically reviewing it against current Department of Health policies. Because the rules do shift, and a trust that worked 7 years ago may not hold up under today's review standards. Florida is the newest entry on this list, and Florida is the state most likely to catch retirees by surprise, because a large portion of the affected families moved to Florida from somewhere else and assumed their previous state's rules would continue to apply. They do not. Medicaid is administered at the state level, and the moment a senior establishes Florida residency, Florida's rules govern. Florida's Medicaid estate recovery has historically been more modest than the most aggressive states on this list, but enforcement has tightened significantly in recent years as the state's over 65 population has grown. The Agency for Healthcare Administration has expanded its review of recipient estates, and the office has increased the frequency with which it files claims in Florida probate courts against recipient estates. The specific trap for snowbirds is this: a senior couple retires to Florida from a state like Pennsylvania or New Jersey, where Medicaid estate recovery is comparatively narrow. The couple buys a Florida home, establishes residency, and one spouse later enters long-term care under Florida Medicaid. That spouse passes away after 2 years in a facility at a commonly reported Florida care cost of $10,000 to $13,000 per month, producing a claim in the range of $240,000 to $312,000. Because the care was received under Florida Medicaid, Florida recovers against the Florida estate, which includes the Florida home, regardless of where the couple previously lived or what protections that previous state provided. Therefore, the act of establishing Florida residency, which retirees do specifically to escape higher taxes and colder winters, simultaneously exposes them to a Medicaid estate recovery regime they may know nothing about. The Florida Homestead Protection, which many snowbirds assume protects the home from all creditors, does not operate against Medicaid estate recovery the same way it operates against ordinary creditor claims. Federal law requires the state to recover, and the Florida homestead exemption, as historically interpreted in probate, has been limited in its application to certain Medicaid claims against certain estates. But Florida also offers one of the strongest planning opportunities in the country, which is the Florida Ladybird Deed, technically known as an enhanced life estate deed. The Ladybird Deed allows a Florida senior to retain full control of the home during life, including the right to sell, mortgage, or revoke the transfer, while automatically transferring the home to designated beneficiaries at death. Because the transfer happens at death and the senior retained full control during life, most interpretations place the home outside the recipient's probate estate, and Florida's Medicaid estate recovery has historically operated primarily against the probate estate. Therefore, the mitigation commonly used in Florida for seniors who still qualify based on age and health is a properly drafted Ladybird deed filed in the county where the home is located, supplemented by beneficiary designations on all financial accounts, and in higher value estates, a pour-over revocable trust to handle non-real property assets. But a Ladybird deed, drafted by a non-Florida attorney or downloaded from a generic online template, frequently fails to meet Florida's specific recording requirements, and a deed that fails to record properly provides no protection at all. The final Florida trap is timing. The Ladybird deed must be executed and recorded while the senior still has legal capacity and is not already in a facility. A senior who has already been admitted to long-term care or who has received a cognitive diagnosis that calls legal capacity into question often cannot execute a new deed at all because the county recorder or the attorney drafting the deed will refuse to complete it without a capacity determination. Therefore, the window to use this tool is narrower than most families realize, and waiting until a health crisis to address the home is nearly always too late. Therefore, the rule across all 5 states is that the family home is never as protected as families believe it is, and the assumption that a will, a joint tenancy, or a verbal agreement among siblings will carry the home through a Medicaid event is almost always wrong. The state's claim is built into federal law, reinforced by state statute, and enforced through administrative mechanisms that operate whether the family knows about them or not. But the rule also allows for legitimate planning, and the planning works when it is done correctly, executed with the right documents, and timed outside the 5-year look-back window. The tools commonly used are irrevocable Medicaid asset protection trusts, Ladybird or enhanced life estate deeds where state law permits them, transfer on death deeds in states that recognize them, caretaker child exceptions for qualifying households, and combinations of these tools layered to address non-home assets like retirement accounts and investment portfolios. Therefore, the action step is straightforward, but is not a single action. It is 3. First, find out which Medicaid estate recovery regime applies to the state the senior lives in, and specifically, whether that state uses a narrow probate estate definition or an expanded definition that reaches joint property, trust assets, or the surviving spouse's estate. State Medicaid websites publish this information, but the language is dense, and the practical interpretation is best confirmed by a local elder law attorney. Second, locate an elder law attorney who is licensed in that state and who specifically handles Medicaid planning on a regular basis, not a general estate planning attorney who drafts wills. The fee for an initial consultation commonly ranges between $300 and $600, and a full Medicaid asset protection plan, including an irrevocable trust, deed work, and beneficiary updates, commonly ranges between $4,000 and $9,000. Depending on complexity and state. Third, do the work while the senior is in good health and before any long-term care event is reasonably foreseeable. Every tool in this video requires the senior to have legal capacity at the time of execution, and every tool, except for certain emergency planning options, requires time to clear the 5-year look-back clock. A plan started today protects the home in roughly the year 2031. A plan started the day a senior enters a nursing facility protects almost nothing. The states on this list changed their rules. The federal floor does not. The question is never whether the state has the right to recover. The question is whether the family did the work in advance to make sure there is nothing left in the estate to recover against.